reported to them. Those that have been sentenced, how did they go? What was it? Who was even the prosecutor? And he go to the court martial, who are the members? I know one of the members of the court martial in Moroto was with me in high school. He didn't even finish his senior 5, and I have never seen him in court. So that's the people who sentence other people, including you with your court. If it's a chairman Baka, you will suspect you have a gun when you are putting on something green. We can take you there and you serve very nice sentence of 20 years for appearing to be dressed like my general brother here. So it's a pain, and I think we need to have this to organize it as court as a directive, that whoever it is, and I like the second one, where the offender commits an offense beyond those provided under the jurisdiction be vested in the applicable civil code. That's so important. Yeah. Why we should be able to filter out? Why should we push it to military when it could be the civilian code? Or if the rules of equality provide, why should rank matter in a court martial? Maybe my brother can explain. You're an offender, and you must be equalized before the law. So some of these things I think provided, and I like tenure should be like as much as possible with like the one in the ordinary courts in courts here. But the center of gravity is qualifications, the rules of evidence, and this impartiality, especially in this court martial. If we get this right, I think we'll be comfortable.
Do you want to tell us about the
security forces have done quite a significant role, and the local leaders to disarm the population? You can't believe it. The population of Karamojong are about less than 1 million people, but they had guns almost more than 50,000, and that's the size of our army. AK-47. Equivalent to the army in Uganda, 50,000. Those are more guns. So to remove those guns in almost every hand, is really, I think it's one of the best policies that the NRM has done in Karamoja, to remove guns. Because they were like walking sticks. And they were so dangerous, even to kill them by mistake, to kill them, the owners when they would get drunk. So peace has returned. A number of things have happened. I can tell you, one of them is we stopped the Kenyans to Turkana from entering Uganda with guns.
That my neighbor here can understand why I'm here. I'm Betty Nambo Zebachideke, the MP from Kono Municipality. I'm also the Shadow Minister for Internal Affairs and a member of the Defense and Internal Affairs Committee. Mr. Chairman, I'm sorry that I'm here for the first time, but I will be briefing you later on why I wasn't able to join you for the last 2 days. Mr. Chairman, having said that, I want to pick it up from where Honorable Katuntu has signed off, especially by citing a fact that not necessarily that members of this committee are lawyers, and we are supposed to depend on our technical people for guidance. First of all, I wish to know, I've been reading through their presentation, and specifically page 2, where they cite, they say that they received some guidance from the Attorney General. And I wish to know what happened to the provisions of Article 120 that provides that the office of the DPP is not supposed to be instructed around by any person or authority. These guidances, how do they consider them? These are instructions being given the office of the DPP politely? So when you have a judgment is given by the Supreme Court. Is it in order that the same judgment is again subjected to the guidance of the Attorney General? more, especially so when the Attorney General himself was an appellant in that case. He was not satisfied with the judgment of court, and that's why he went to the Supreme Court and he lost. Having lost in the Supreme Court, then he turns around to guide on how to implement a judgment that has not been given in his favor. Is it fair?
And then recommended to the General Court Martial. Help me build a case there. Secondly, in one of the orders, because the Constitutional Court the General Court Martial had been ruled unconstitutional, the court ordered that all pending matters be transferred to your office. Now, here on page 3, you say that you received 45 investigative files. Are these different from sanctioned matters? When you say you received investigative files, are there files you received that had been sanctioned and pleas had been taken?
How many were pending to be received?
Thank you, Mr. Chairman. I want the office of the DPP to help me, because we are disturbed with a situation where, if it were not for the civilians, personally the rest would be okay. But we are disturbed with a situation where the civilians are being moved to the General Court Martial for offences committed in regard to unlawful possession of firearm, but also related cases. But I want you to help me in this, because there is somewhere where they talk of specialized jurisdiction. In one of the declarations of the Supreme Court, on page 3, and that is 3, the General Court Martial created under Section 195 of the UPDF Act is a subordinate court of law, but with a specialized jurisdiction. Now, when you go to page 6 of your submission, help me build a case on this in one of the advisory orders, which is D.
As to the requirement of exceptional circumstances, according to the Supreme Court, the court was clear that trial of civilians should only be provided for after demonstrating that the circumstances are so unique and exceptional that the civilian courts cannot perhaps be the most suitable venue for trying those civilians. First of all, and this is in response to General Masiko, you should make no mistake that military courts are useless. No. Military courts or court martials play a very important role world over. I have personally researched. You find it everywhere, even in developed jurisdictions. America uses it. You won't find any country where it doesn't exist. Now, the only difference between General don't get happy yet.
Yes. Just saying.
Yes, the only difference is that where these courts operate elsewhere, their jurisdiction is well defined. It is not all over the place. And that is what the Supreme Court is telling us, that the circumstances should be exceptional. In our opinion, as we have recommended, we think that those exceptional circumstances should be restricted to offenses under the UPDF Act. Otherwise, if you provided that they can have powers to preside offences in any other law that this parliament makes, first you will be creating a contradiction. It will be some sort of vote of no confidence